economy, saving money, basically, saving time. But I think we reached a point in this case where that issue of your discretion is now a legal issue. And whether or not it arises, and I don't mean this on a personal level, but whether or not it arises as an abuse of discretion is something that the Court of Appeals has set forth in the Mahubian case that I know you're familiar with. I tried to break that down in terms of not only the law in that case, but the facts in that case, and the analogy to what occurred in this courtroom. But I just want to make it clear today that at a pretrial level, Mr. Pilato in the motion papers predicted what was going to happen. And we indicated the need for a severance and the fact that there would be an unduly prejudicial occurrence if it wasn't provided. Now, that was one motion that was in pretrial. And then after the suppression hearings, the court, in fact, did suppress some of the defendant's statements. There still remained other statements. But what we put forth was a second motion, pretrial, requesting severance on the grounds that in addition to the other statements that could come in, that there was also prejudice by way of the forensic evidence. And we noted that Colin Ridout had not brought a motion for severance, and that we fully anticipated that Colin Ridout's attorney would be in a position as a second prosecutor against Laura Ridout. That prediction turned out to be true. And that happened many times during the course of the trial. I didn't keep count. I would venture to say that on no less than a half a dozen occasions, maybe a dozen occasions, I moved for severance during the trial based upon questions that were being asked by all co-counsel in which answers were being directed in a negative way toward Laura. Now, the people in their response avoid the entire issue of the impact of having a second prosecutor. But the court's initial position in terms of a discretionary call is now one that is still before the court, and one in which this court can correct that issue today. It's the only time it could be done. The court has the power, has the civil authority to grant this motion at this time, to vacate this conviction, and to allow for a separate trial. I will tell you that in my experience, and I've been in trials with as many as 10 defendants, this was extremely difficult. It was extremely difficult because Mr. Pilato and I represented the mother of two co-defendants. And the spillover effect at a joint trial is so difficult to overcome in most cases, but it's particularly difficult to overcome when this relationship comes to a head. So I won't go any further. I will make a note that the case that the people cited, People versus Cruz, I don't think it impacts their position in any way, but that case was reversed. It's no longer good law. But the Mahubian case is good law. And the facts in that case, while different, the analogy is right there with this case. Thank you.
Thank you, sir. Counsel?
Very briefly, Judge. In our motion responses that we rest on, that we noted that it's a two-part test. And our position is that the first requirement of core defenses in being irreconcilable differences wasn't met. We've laid out how we think that the core defenses of each were similar. Attacking DNA, contaminated, attacking an expert as being unreliable. And submit that first test they failed on. And additionally, I'd say the second test they failed on, because even if any alleged conflict, that alone didn't alone lead to a conviction. And we laid out the breadth of evidence that we think supports that conviction. And briefly, when the counsel says we didn't argue the second prosecutor argument, we did cite cases that defendants are basically showing that evidence may be strong against one or the other, that's not really a grounds. So based on that and motions, we oppose the application.
Mr. Dupree, I obviously read your papers and the people's response. You moved pursuant to 330 that any ground which would require a reversal. None of the grounds raised, I believe, require reversal as a matter of law. Your 330 motion is hereby denied. Mrs. Drew, would you like to speak to the court?
Yes.
Come on up.
What I'm going to have you do is say your name, spell both your first name and your last name, and then remember, your obligation is to talk to me, not to them. Okay?
My name is Robin Drew, RobbynDrew. With regard to the sentencing of Laura Ridout for the murder of Craig Rideout, dear Judge Moran, I had the honor in January of 1993 to be a part of one of the best days of my brother's life, his marriage to Laura Basin. They were young, happy, and in love. Together they brought 7 beautiful children into this world. He loved each of them. Little did I know what the future would bring. It is beyond comprehension that 23 years later, I would find Laura in Craig's kitchen, and then that she would be found guilty of his murder, tampering with evidence, and burglary. She had left their marital residence 2 years prior. She had no rational reason to be there in his home that he had only just moved into with the 2 youngest children. Even worse is that one of their children would be found to have been intricately involved in these events, and that another was involved with tampering of evidence. On top of that, Laura tried to involve their younger children in earlier events prior to Craig's death. When Craig would come home to find the youngest children gone and would question who picked them up, Laura would say, "What, you don't know where your children are?" The final statement of this kind that I heard from Laura is when she looked at me while standing in Craig's kitchen saying, "I don't know where he is, but I knew it wouldn't be long before someone came looking for him." Knowing what I now know, I cannot believe the cruelness of that statement. Since my brother's killing, I have fought anxiety, depression, and stress, to the point that now experiencing a chronic pinched nerve requiring medication. I have been worried about not only my husband and all of our children and their response to this atrocity, but the effect that it has had on my mother. She has not only lost her son, but 2 of her grandchildren to jail and prison time. Not only that, but we have not had contact with the rest of my brother's children. We can only hope that we can have some kind of a relationship with them in the future, and hope that we have not been painted with the same falseness that their mother painted their father. I forfeited vacation time from work and canceled 2 vacations to be able to be available to the prosecution. It was of utmost importance to me to be the voice for my brother, as the people who should have been there speaking for him, protecting him, were the same ones on trial for his murder. The act of killing my brother was not an accident. It was not something that just happened. It took planning. It took coaching. Her actions showed total disregard for what happened to her own children as well, virtually leaving them parentless. There is nothing that can be done to bring my brother back. My hope is that he can be remembered for the kind, loving, gentle man that he was, as can be attested by all the people who truly knew him. He will not be able to bridge his relationship with his older children, and his younger children will never get to know him, and that is the saddest part of all. It was his greatest wish. I miss him, his smile, his humor, his support, our conversations, his love of life. Based on the callous and vicious nature of how Laura Ridout murdered my brother, tampered with evidence at his home, and in burglarizing his home, I feel that she should face the maximum amount of time allotted for each crime. Sincerely, Robin Drew.
You can, if you would, continue.
Sentencing for Colin Ridout for the murder of Craig Ridout. Dear Judge Moran, since my brother's killing, I have fought anxiety, depression, and stress to the point of now experiencing chronic pinched nerve requiring medication. I have been worried about not only my husband and all of our children and their response to this atrocity, but the effect that it has had on my mother. She has not only lost her son, but 2 of her grandchildren to jail and prison time. Not only that, but we have not had contact with the rest of my brother's children. We can only hope that we can have some kind of relationship with them in the future, and hope that we have not been painted with the same falseness that their mother painted their father. I forfeited vacation time from work and canceled 2 vacations to be able to be available to the prosecution. It was of utmost importance to me to be the voice for my brother, as the people who should have been there speaking for him, protecting him, were the same ones on trial for his murder. The act of killing my brother was not an accident. It was not something that just happened. It took planning, it took coaching. Colin's actions showed total disregard for what happened to his father and to his other siblings. He showed total disregard for the law. He was old enough to be able to know the difference between right and wrong and did not care. Even when given the opportunity to admit what had happened, he chose the rehearsed lies rather than the truth. There is nothing that can be done to bring my brother back. My hope is that he can be remembered for the kind, loving, gentle man that he was, as can be attested by all the people who truly knew him. He will not be able to bridge his relationship with Colin or with his other children, and that is the saddest part of all. It was his greatest wish. I miss him, his smile, his humor, his support, our conversations, his love of life. Based on the callous and vicious nature of how Colin Ridout murdered my brother, tampered with evidence in his home, and tampered with evidence at Mendon Ponds Park, I feel that he should face the maximum amount of time allotted for each crime. Sincerely, Robin Drew.
I know you're going to talk about Alexander now. If you want to go just to the part that relates to him, that's fine.
Thank you. The act of tampering with evidence, not only at his father's home, but at Mendon Ponds Park, was not an accident. It was not something that just happened. It took planning. It took coaching. Alex's actions showed total disregard for what happened to himself as well as his other family members. Even when given the opportunity to explain what had happened, he chose the rehearsed lies rather than the truth. There is nothing that can be done to bring my brother back. Based on the callous and vicious nature of the tampering with evidence at his home and at Mendon Pond Park, I feel that he should face the maximum amount of time allotted for each crime. Sincerely, Robin.
Thank you, Mr. Brosberry?
Yes, Your Honor. Judge, I know we would ask that Ms. Drew's comments be made part of each of the defendant's records. We would ask that the letters in support of the victim, Craig Rideout, be made part of the record for each of the 3 defendants.
So ordered.
Thank you, Your Honor. Your Honor, I think from the letters, and I know the court's reviewed them, you get a picture of Craig Rideout as a person who cared about his family, cared about his friends, a man who worked at the same job for decades, had coworkers that cared about him, and also was involved in youth counseling. But we're here really for the sentencing on the brutal murder and the cover-up of that murder. Craig Rideout, of course, as you know, was strangled in his own basement, beaten about the head, taken out to Yates County, acid poured on his face, really in an effort, Your Honor, to disappear, to make him disappear forever. So there'd be no answers for the remaining family. There'd be no autopsy. There'd be no arrest. There'd be no trial. So, Your Honor, I submit that the tampering crimes are significant as the murder crimes, because they're part of that effort, and I submit that part is pre-planned for the cover-up of the murder. And there are 2 distinct acts of tampering, of course. One in the basement of the victim's home where the murder occurred on July 18th and 19th, and the other being at Mendon Ponds on July 21st. So addressing as to Alex Ridout and those 2 separate and distinct crimes, I'd submit there was evidence that he was integrally involved with that tampering in the basement, the location of the murder, his father's home. As the court recalls, the efforts of cleanup of blood in his has entered into evidence the glove that had blood evidence on the outside of it for Craig Ridout, and DNA evidence on the inside of it for Alex Ridout. Then the next day, there's evidence of Alex Ridout being out in Mendon Ponds, where there was other evidence related to the murder. And of course, that's a separate location, a separate date, separate and distinct. Submit between the two of those times, Alex Ridout would have the opportunity to not be involved any further, to stop, to not participate, and yet he did. And then at Mendon Ponds, with that tampering crime, there was additional bloody clothing. In particular for him, it was the sweatpants, blood on the outside of the victim, and his own DNA evidence on the inside of it. As you recall, there's also the 5 bottles of Drano with sulfuric acid floating in the pond. And Your Honor, we submitted the case law. It's our position that those 2 separate distinct crimes, the sentencing could run consecutive, and we respectfully request the maximum sentence on each to run consecutive. As to Colin Ridout, Your Honor, we submit that there is evidence for him of pre-planning of cleanup of the murder before it happened. Evidence of his participation in the actual murder, and then evidence of him participating in the tampering, the cleanup of that murder. As you recall, Your Honor, the Monday before the murder, he was the person on video purchasing those 2 bottles of drain cleaner with sulfuric acid. On the Wednesday morning, I think it was 12:30 in the morning, he's the person being dropped off by the car, walking into the store, buying 8 separate leather gloves and a shovel. And those are items, as you know, were recovered. The shovel beads and the gloves at the 2 tampering locations with blood evidence. Your Honor, also was significant in that car where Colin Ridout was arrested in Mendon Ponds is that duffel bag. As you recall, that duffel bag had paracord, and paracord was of the same style and color as the paracord made to use one of the murder weapons, the garrote. And you recall, Your Honor, that that garrote had evidence that was carefully made. It had metal-type handles, it had duct tape to secure the handles, it had secure knots. And what was significant about those knots, as the court will recall, is the knots in the garrote matched the knots in the paracord in the car where he's convicted of tampering with evidence. Judge, we submit that detailed manner in which that garrote was created. And we submit that the blood evidence in Mendon, which included the Wrangler jeans, the Wrangler jeans are described as saturated with blood, and Wrangler jeans that have the DNA evidence on the inside of them, consistent with Colin Ridout. So we submit by that clothing, by his purchases before the murder, that really shows his pre-planning of those events, his intent, and it's over a course of days. During those days, he could have said no, he could have backed out, he could have stopped, but instead now he's in court, convicted of the intentional murder of his father. Based on that pre-planning and all that evidence, we ask for the maximum sentence for Colin Ridout. Your Honor, as to Laura Ridout, we'd also submit there's evidence that she was participated in the pre-planning of the cleanup, the murder itself, and the cleanup after the murder. As you recall, she was with Colin on the video on the Monday before the murder. And Colin purchased those 2 bottles of drain cleaner. She was also in with another person on Tuesday when the purchase was made of the tarp, the bungees, and the 3 bottles of drain cleaner with sulfuric acid. And as we know, of course, it's 5 bottles found at Mendon on the Thursday after the murder. Judge, the defense has submitted in their papers an unsigned copy of what's labeled as a statement of Laura Ridout. And it's significant. She says that she did go to the victim's house on that Wednesday morning only to pick up the 2 youngest children. She said she then saw the bloody scene in the basement and had a concern that one of her children may be responsible for the scene and may be responsible for Craig's absence. Judge, I'd submit, why would a mother, seeing that, assume that it's one of her children? And why not be concerned that possibly it's a third-party person that still poses a danger to herself, to her family, to other family members who are not there? But instead, what did she do? She waits at the house for hours, cleaning. And in the statement, it's unsigned, but the statement says cleaning surfaces with blood. And Judge, at that point, she doesn't know whose blood that is. She has no DNA reports, and yet she's cleaning. But in that statement, she also admits that the genes of the victim's blood were hers. I'd submit that's the Massimo genes that were found in the car with Colin and Alex at Men and Ponds. And she admits the tampering in the basement. Judge, I guess my point is, at the center of this trial, from the pre-claim and the murder, and the cleanup after murder, is Laura Ridout. And that we had evidence that occurred over a matter of days. And that shows the intent. And that shows her responsibility. And then based on that and the conviction, we would ask for the court for the maximum sentencing on those charges. Thank you.
Thank you, Judge. First, I would address the motion I made related to consecutive versus concurrent sentences. I believe I've provided case law to the court. I've also responded to Mr. Prosperity's cases. As the court is aware, I made not one, not two, but three heartfelt requests for a bill of particulars in this matter, asking repeatedly, what is it that Alex Ridout is alleged to have done? The bill of particulars was addressed not only to the accusations that he was involved in the murder of his father, they were also specifically pointed to the accusations that he had tampered with evidence at New Wickham and at Mendon Ponds. I asked once, the prosecutor denied to particularize the allegations. I asked a second time. They refused to particularize the allegations. I filed a written memo with the court, again, citing the case law, rehashing the procedure law, the requirements for a bill of particulars, the purpose of a bill of particulars, asking the court to order Mr. Prosperity to please tell me what my client allegedly did, not only with regard to the allegations of murder, but with regard to the tampering. The court denied that application. We walked into this trial not knowing what it was that Alex Ridout allegedly did. In all candor, I still don't know the answers to those questions, but most importantly, for purposes of concurrent versus consecutive, neither does Mr. Prosperity. The people never responded to that request. Because they never responded to the bill of particulars, which was a calculated decision on their part to have us wander into this blindly, they cannot now stand here and say that the tampering at New Wickham is different than the tampering at Mendon Ponds. They're absolutely prevented from making that allegation. That's something they had not one, not two, but three opportunities to inform us of prior to this trial. Mr. Prosperity has refused to provide that information, and the facts of the case at this point, as it's been produced in front of the jury, indicate that it is entirely possible and actually quite likely that the tampering that occurred at New Wickham is the exact same act of tampering that was still ongoing in Mendon Ponds Park. I believe I gave the court several different scenarios in my papers that can discuss how that is, I believe, what the prosecution's theory was. Because it was the same act, the sentences must run concurrently. So I'm renewing my request that the court, as you denied my 330 motion, that the court sentence Alex concurrently on both counts of tampering. It would also
let me allow the people to respond.
The
Right
case
now?
that we submitted,
Well, do you have anything other on consecutive versus concurrent?
No.
Let them respond to that.
the case that we submitted, I'd say to submit, say that the key is to look at the mens rea of the activity. And what we have is two separate, which we specified. It's two separate dates, two separate locations, two separate tamperings. Of course, one being the basement of 135 in Wickham, and the other being Mendon Ponds. And they're on separate dates, separate times, separate locations, and separate property. So to submit that supports the fact that they're two separate, distinct activities, two crimes.
Alex that it was too late for Mr. Presbury to come in and say that now. The time to have made that argument was prior to trial when he was given the opportunity, at which point he would have been obligated to tell me and Alex exactly what was it that he tampered with at New Wickham and how did he tamper with it, and what did he tamper with at Mendon Ponds Park and how did he tamper with it. Because he refused to do so, I believe that his bed has been made in this area. He cannot get up now and say that it is two separate acts. It is clear from the evidence that it most likely and probably was one act of tampering related to concealing bloody clothing from the homicide. I'd also ask that the papers that we submitted in the letters in support of Alex Ridout be made part of the permanent record.
So ordered.
Thank you. I'll start my remarks related to the actual sentencing by extending my condolences to the family and to Ms. Drew. I listened to her speak, and this is probably the first time I've had the opportunity to listen to her speak, and I hear the anguish in her voice. And I can certainly empathize with what she and the rest of the family are going through enduring the loss of her brother, their son, their uncle. But nobody ever seems to pay attention to the fact that Alex has lost his father. There was such a quick rush to judgment in this case. There was such a quick conclusion that Alex Ridout was involved in some way in murdering his father that he did not deserve even the slightest bit of sympathy or consideration. I was there when he found out his father was dead. It happened in court at his arraignment. The district attorney who was present at the arraignment just stated it into the record as if it was nothing. They found a body. They're pretty sure it's Craig Ridout. So there's a murder attached to this case in the bail application. It's the first time Alex Ridout found out his father was dead. With just that much fanfare, with just that much empathy, with just that much consideration. A 19-year-old boy who's never been in trouble in his life is informed that his father has been found dead. He told me later, to this day, I'm the only person who extended condolences to him. Because everybody just assumed he must have known, he must have been involved in it. And we're going to bring the court back. The court had an opportunity to review the conversations that Investigator Bolton had with Alex at Mendon Ponds. You had an opportunity to observe Alex's appearance, how he's behaving with Investigator Bolton. And contrary to what Robin Drew just said, Alex did not spin lies. He didn't try to deceive anybody. He told Investigator Bolton what he knew. And if the court will recall, what he said is, I don't know what happened. I don't want to know what happened. He was caught up in something that was huge and way bigger than any 19-year-old boy should ever have to deal with on his own. Effectively, in that moment, Alex Ridout was orphaned. His father is dead. His mother is accused of the murder. His brother, who is the person he looks up to more than anybody else in the world, is charged with that same murder. So while I appreciate the terror and the horror of what Ms. Drew and the other family members have gone through, I want to bring this through to what Alex Ridout has had to go through at his age, and knowing the type of person that he is. We've submitted numerous letters to the court, and the court's had an opportunity to observe him repeatedly during the course of the trial, during hearings, during pretrial matters. This is a kid. He's a big kid. He's tall. But inside, he's still a kid. And what we've heard about him is 100% consistent. He's sensitive. He's thoughtful. He's generous. He's caring. He's non-aggressive. He doesn't have a temper. These qualities, his eagerness to please adults, his eagerness to be accepted, his eagerness to be a member of the family, was exploited by his father and, I suggest, by his mother. His father, as the court is aware, apparently did not appreciate these qualities in his son. He did not appreciate that he had a child of this level of intelligence. He did not appreciate that he had a child this sensitive. And he bullied him for it. He had a mother who sensed that he would do whatever he was asked to do in an effort to be loved and be accepted by his family. And she exploited him at 19 years old. The court has had an opportunity to appreciate that he is caught up in a divorce that he didn't ask for, that he didn't want, that he played no part in, yet nevertheless he winds up on trial for murder. And I'm still asking myself, how did he wind up in this position? I went through every page of the discovery. I went through every DVD. I looked at every picture. And after looking through that mountain of evidence, I would cross it off. Where's Alex? Where's Alex? Where's Alex? No Alex. Why is he here? Why is he indicted for this case? I sat through the trial. There was never an answer. I listened to Mr. Egan's opening statement. Is he going to tell me now? Why did they think he was involved? He never did. Because he didn't know. As I recall, he suggested to the jury, you guys figure it out. 20 binders of discovery. An incredibly exhaustive investigation by the Sheriff's Department. And they still couldn't answer that question yet. Nevertheless, this kid had to sit on trial for his life. He had to sit and contemplate every day whether or not he was going to live his life behind bars or whether or not he was going to live a free life. Was he going to live it with his brother? Was he going to live it with his mother? He's already lost his father, his little brother, his little sisters. What's going to become of them? Those are the anxieties he had to live with at this age. That's what he had to live with every day when he came to court, respectful and appropriate to the authority of this court. And I never heard any evidence that he was involved in the murder. Minutes after the murder, Investigator Bolton was interviewed. And I watched that interview on television. And he was asked, what do you think about the verdict? Do you think anybody got away with it? And he said, yeah, I think Mr. Tucci did. I think Tucci got away with murder. You know who he didn't think got away with murder? Alex Ridout. Because honestly, I don't think anybody ever really believed for a second that he was involved. He just got thrown into the mix. And he had to endure watching his very life hang in the balance, slip away from him, even though the lead investigator in the case, who knew just as much, if not more than we did, didn't believe for a second that he was involved. And then I watched another interview with the district attorney of this county. And she was asked, along with Mr. Prosperi, why do you think the boys got involved? Plural. And her response was, well, I think the boy entered into an agreement. Single, not two. Not even she believed that he was involved. But this didn't prevent them from putting him on trial for it. So when we discuss punishment for Alex, I am begging the court to consider for a moment what the world of adults has taught him and how much mercy have they shown him. This is a kid who's never done anything bad to anybody. He's never treated anybody disrespectfully. He's never been rude. He's never been vulgar. He's never been abusive. He takes care of his little brothers and sisters. He's loving. He's supportive. He's brilliant. He poses an incredible intellect and possibilities to our community and to the future, but none of that stopped adults from taking advantage of him. That didn't stop the bullying at home. That didn't stop his mother from taking advantage of him. It didn't stop Mr. Prosperi from indicting him for murder. I'm asking the court to let it stop now. He's been punished enough. I'm asking the court to take into account what type of individual he is, the opportunities that he presents, the future that he has ahead of him. It's bad enough now that he has a felony on his record and how that's going to compromise him going forward. I'm asking the court allow him to get back to his life as soon as humanly possible. Allow him to restore himself to his family, to take care of his little brothers and sisters, to be there and try and mend the breaks that have been caused. Nobody ever thought he was involved in that, yet he had to stand trial for it. And I suggest to the court that that is more than punishment enough. With regard to the tampering, again, keep in mind, this is a child that time who wanted nothing more than to please. He's caught between a rock and a hard place. I saw some of the letters that were submitted to the court, and Ms. Drew just said, he knew and he didn't tell. And that's an easy thing for anybody on the outside to say, oh, I would call the police immediately, but would you? He loves his mother. He loves his brother. He has loyalty to his family that superseded the loyalty he felt to calling the authorities. And for that, he has paid an extremely heavy price. Just asking the court end this now and sentence him to a sentence of time served.
Alexander Ridout, you have the opportunity to speak to me. You don't have the obligation. Is there anything you'd like to say?
Alex has a letter for the court. I don't know if he wishes to read it or just provide it to the court.
Want to give it to me? Is that what he said?
Yes.
Ms. Bianca, you can read it. Marinello?
Thank you, Judge. Judge, in terms of the sentencing memorandum that I submitted, along with the support letters that I submitted, I'd ask that those be made a part of Colin Rideout's record. I did submit also a few extra support letters by email that weren't attached to the sentencing memo. I would just ask that those be attached and included in the record.
They've already been printed and attached, and so
Judge, I would join in Ms. Sianka's analysis of the concurrent versus consecutive argument as it relates to the tampering with evidence charges as it relates to Colin Ridout also. Without going through the same legal arguments, we would join in Ms. Sianka's legal arguments related to that. Judge, in terms of Colin Ridout's time since the conviction in this case, he has been held in the Monroe County Jail. There has been a no contact order in the jail that he not have contact with Alex Ridout. I'm not sure why that is. I don't know whether or not you have any control over that. Alex or Colin Ridout will be in the Monroe County Jail probably for about the next week. And I just ask that if you do have the power or the ability to order that the no contact be removed so that Colin Ridout can have contact with Alex Ridout prior to he being transported to the Department of Corrections, that you do whatever in your power you can to allow that contact to happen.
Mr. Parinello, I will simply tell you that the running of the jail is the responsibility of the sheriff, and I'll defer to his judgment.
Judge, in terms of the placement of Colin Ridout, I'd ask that you recommend that he be placed as close to Rochester, New York as possible. As you are aware, he has a fiancée that lives in Rochester, New York. His grandparents live in Rochester, New York, and he would like the ability to have visits with them, and it would be easier for them to have visits with him if he is placed as close to Rochester as possible.
And Mr. Parinello, I don't run the prison system either, nor will I attempt to. The prison system will place them where they deem him most appropriate.
And the other, in terms of his placement, Judge, as you are aware from some of the discovery, Colin Ridout unfortunately was not permitted to finish his higher education. He entered into college, and based on the fact that his parents did not support him in that endeavor, he was unable to finish. He does have a drive to become educated, and we ask that you recommend that he be placed in a facility that has higher education classes so that he can take part in any of those higher education classes.
Same answer.
Judge, Ms. Sianka talks about Alex Ridout, the kid. Colin Ridout never got to be a kid. He didn't have that benefit. Based on the lack of parenting that he received, the chaos in that household that he endured for all those years, he was forced to grow up way before any 22-year-old kid should have to grow up. Those 7 children did not receive parenting. They received what amounted to parenting from their oldest sibling, Colin. He's the one who had to take care of them. when their mother was sick and she couldn't care for them, she couldn't get out of bed. You read the letters. Who had to take care of them? Colin. Why? Was Dad away? No. He didn't care to take care of them. That was Colin's job. Judge, we're not here to bash Craig Ridout. It's just simply a fact that we want you to take into consideration. What happened to Craig Ridout is sad. We all feel for Robin Drew and her family. But that doesn't lessen what Colin Ridout had to endure for 22 years. What the jurors didn't hear. You knew some of it. The chasing up of the stairs, the pulling down the stairs, the kids having to lock themselves in the room, the calling of the police, the sex abuse allegations. Colin had to protect his siblings. But that all happened way before the summer of 2016. Way before. But that was just part of what Colin Ridout had to do. He was the only parent. He was the only one who took care of those kids. When he was told to jump, his only answer was how high. That's what he had to do. That's why Alex looks up to him. Colin took care of Alex, as well as his other 6 siblings. No kid should have to do that. Judge, we look at the trial in May of 2016. Colin Ridout was on top of the world. He got engaged to his longtime girlfriend, his high school sweetheart. She had graduated from college. She had a good job out in the Midwest. He got engaged. They were planning a wedding for October 8, 2017. Obviously, that wedding never occurred. There was no motive. Zero motive at the time of trial. There was nothing. As I said during my closing, Colin wasn't getting divorced. Laura's the one moving down to North Carolina with Mr. Tucci. If you believe some of the stories, those are the two who wanted to take the children down to North Carolina. Colin's going out to the Midwest. He had no motive for this. So you have to think in the back of your mind, who had the motive? We know Laura had the motive. She wanted the children. Craig had the children. There's your motive. Who wanted Craig out of the picture? Laura did. Not Colin. Colin had nothing to do with that. He was moving on in his life. At trial, there was no proof that Colin Ridout was the principal actor in the death of Craig Ridout. He was charged as the principal or an accomplice. As we sit here today, was he a principal or was he an accomplice? You still don't know. Was he either? The bloody jeans. At the beginning of the trial, I think we all saw the focus was on Colin. The focus of Mr. Prosperi's case was right directly on Colin. Who did they make a big placard of and show to the jury? The shirt, the bloody pants, the sneakers. They didn't do it of Alex. They didn't do it of Mr. Tucci. They didn't do it of Laura. Solely Colin. Well, the only part of that fell short was when Mr. Kish came up and testified. He testified regarding those jeans. What didn't he say? That there was coagulated blood on those jeans. He didn't say that. If he had said coagulated blood on those jeans, then he puts those jeans very close in time to the death. He did not say that. But what did he do? He came in here got paid $25,000 to make up a story on the day he testified. Went into the grand jury, no testimony about spatter. No testimony in the grand jury. He was asked about the jeans. No testimony. He wrote a report after this extensive investigation. He wrote a report about the jeans. He did not indicate in that report that the spots on the jeans were caused at or near the time of death during a spatter incident. He did not put that in his report after all that investigation. But what did he do? The day he came in to testify, all of a sudden he has an epiphany after being paid $25,000. He's got an epiphany after meeting with Mr. Prosperi, getting on the stand. Now, oh yeah, those jeans were there at the time of the spatter event. What if they weren't? What if Laura killed the person she had the motive to kill? And then what if she gets her boys to come on in? And who's the first person she's going to call? Colin. He's the one that's taking care of everything. She calls Colin to come in and take care of this. Medical examiner did not say that the garroting happened first and the hit on the head happened second. Hit on the head could have happened first. The hit on the head happens first and Craig is knocked out. Anybody could have garroted him. Anybody. That means anybody could have killed him. What if Colin simply came over because his mother asked him to help out again, like he had done for 22 years? She asked for his help again, cleaning up. What if that happened? And Colin's going to go and sit in a maximum security state prison. All 5'5", 130 pounds of him is going to go sit there for years and years and years. What if he only helped clean up? Mr. Prosperi talks about the knots in the paracord, the left-handed knots. Colin's not left-handed. Alex isn't left-handed. Laura's not left-handed. There's one person that sat here during this trial that was left-handed. He's not sitting here today. Testimony was left-handed knot in the paracord. Mr. Prosperi mentions it. There's only one person here that was left-handed, and he's not sitting here today. Judge, and finally, when confronted at Devil's Bathtub, and Investigator Bolton takes Colin out and starts talking to Colin, what does Colin say? I'm worried about what may have happened in that basement. You know what was said in that statement. That didn't come in at the time of trial. But you know, you can take that into consideration in your sentencing. I'm worried about what could have happened in that basement. My mother gave me these bags and told me to get rid of them. That's what Colin Rideout's mother did. Mr. Prosperi talks about Laura's statement, or a statement allegedly given by Laura in her sentencing memo. Blaming her kids still. She's still blaming her kids. Her son, her first son, who she gave birth to, she is blaming still. That's the same person at trial that refused to take responsibility for what she did and let her son go down for something that he did not do. I've talked to Colin at length numerous times. He's a nice kid. He had a great life ahead of him. He's polite. You read the letters from family. You read the letters from his siblings. He's a good kid. It's a shame what happened here. But don't let it get any worse by giving him a similar sentence to someone who had a motive to have Craig gone. That would be a shame. I've also talked to him about the possibility of speaking here today and giving a statement. It's my advice to him that he not. Obviously, he has appellate issues coming up. I don't want you to hold that against him. You've been doing this long enough. You understand. For appellate reasons, my advice is not to have him give any statement, and I don't think he's going to give any statement here today. But like I said, I hope you don't hold that against him. I hope you do take into consideration everything that I have said today and everything that you saw during the trial, and that you sentenced Colin Ridout appropriately. Not similarly to others. Appropriate, given the conviction that he has. Thank you.
Colin Ridout, you do have the opportunity to say something, but you don't have the obligation.
May I briefly confer with counsel?
Certainly.
So I don't necessarily see No, thank you, Your Honor.
Mr. DePrimo.
But Mr. Plow is going to address the
Sure.
Just very briefly, Mr. DePrima is going to deliver the remarks on behalf of Laura Ridout. However, shortly after noon today, we received an email from Mr. Egan asking for, I believe, the first time that the sentence of Ms. Ridout be consecutive. He attached some cases. I had the opportunity to print the cases that he cited, however, I haven't even fully gone through them. I just wanted to address the legality of his request for consecutive sentences because it's our opinion that the case law as well as the penal law, and I would specifically cite penal law section 70.25 subdivision 2, which says sentences imposed for 2 or more offenses may not run consecutively. 1, where a single act constitutes 2 offenses, or 2, where a single act constitutes one of the offenses and a material element of the other. I would submit, certainly with regard to the burglary and the murder charge, that there is a material element of one that's part of the other. So it would be our position, Judge, that the sentences should not run consecutively. Furthermore, with regard to the pre-sentence report, Judge, I've already submitted our objections and our requests, and I understand from your comments to Mr. Farinello that that's already part of the record.
It will be in the case of all the facts.
Thank you, Judge. So I would let Mr. DePrima deliver the further remarks.
Judge, I'm just going to quote it, if you don't mind. Judge, very briefly, it's interesting what you just heard. In fact, what I'd like to do at this time is renew my 330 motion, because what we just heard from both Ms. Ianca and Mr. Farinello is typical of what happened during the trial, and that is the finger pointing at Laura Ridout. And that results in irreconcilable differences between these parties, antagonistic defenses, and to indicate that that is not undue prejudice for Laura Ridout is a direct violation of the Mahulian case in the Court of Appeals rulings in the progeny cases. Having said that, I don't expect the court to grant the motion since you've already denied it once.
Denied again.
But I think this is illustrative of exactly what happened during the trial and the danger of what we had in a joint trial. And to address one issue that Mr. Prosperi raised, he said in reviewing the statement of Laura Ridout to the court that there was a statement in there about her suspecting one of her children. Why would she suspect one of her children? Mr. Prosperi knows why she would have suspected one of the children. Because he's fully aware of the dialogue that occurred by way of emails between Colin Ridout and his father, Craig Ridout, from approximately May 31st until the date of this death. And the anger that was simmering in Colin Ridout. He's fully aware of that, and Mr. Parinello is fully aware of that as well. Now, that didn't come out at trial. It wasn't allowed in trial. But that's what happened. And that's why she was fearful that Colin may have been the one that caused this. Now, as criminal defense lawyers, we're often asked the question, how can you represent people who commit heinous crimes? And after immersing myself over the past 40 plus years in this vocation, the answer is easy. But for the grace of God, there goes I. In this Hall of Justice, we learn over time the ideology of criminal behavior. Some people are born into poverty, not just financial poverty, but we know that poverty is a great inducement to crime, causes a lot of crime. Many others have drug and alcohol addictions. Where that comes from, what kind of deprivation they had in their lives, whatever dehumanizing mannerisms resulted in this, there's usually some basis for it. And there are crimes of passion, where people, because of their human emotions, can't figure out a better path to take. And finally, there are crimes that are just pure evil. And these are committed by people that dissociate themselves from our moral standards of what's right and wrong. I don't mention these as excuses for my client to avoid personal responsibility. Rather, I mention them because I don't believe any of these categories apply in this case to Laura Ridout. As criminal defense lawyers, we have the opportunity to learn and know our clients as very few can. It's a very unique opportunity that we have. In this particular case, other than her parents, siblings, and children, I believe Mr. Pilato and I know Laura Ridout better than anybody in this courtroom. We have spent together literally hundreds of hours interviewing her, examining her medical records, her school records, the entire divorce proceedings, interviewing her parents, her siblings, her children, albeit not Alex and Colin. As a result, I've come to know her inner self, as few others do. And in coming to know this inner self is my judgment that she neither possessed the state of mind, the physical capability, or any motive to be a principal or an accessory in the death of Craig Ridout. I also have come to believe that she doesn't have an ounce of evil in her, contrary to what you just heard from both counsel. So let's turn to her inner self. Laura was born into a loving and devout Roman Catholic family. She was the oldest of 5 children, with 3 sisters and a young brother, Gregory, who was a Down syndrome child. He's not a child, he's in his 30s. But I mention that because he was born at a time when Laura was about 10, 11 years old. And she saw this young boy lacking a chromosome and the gift he brought to that family. From an early age, she was taught by her parents, again, strong Catholics, that moral values are rooted in our natural law. And as a result of that, she became a devout, from an adolescent on and to this day, a devout supporter of the Right to Life movement. And I'll tie this together. Because that Right to Life movement is ensconced in the Catholic moral doctrine of the sanctity of life, all life, including the life of Craig Ridout. I have some remarks to make about him today that may not be easy for everybody in the family to hear. For that, I apologize. But I have a job to do here, and I have a job to represent my client with what I know to be the facts. But despite these remarks, make no bones about it, Craig Ridout did not deserve to die.
Excuse me. I appreciate what you're attempting to do, but please address the court.
Yes.
Thank you.
Clearly, I just want the family to understand there was no basis for him to die. There's no rational basis for it. From all accounts, Laura Ridout lived her life based upon these moral precepts that she grew up with. She attended Catholic schools. She attended a Catholic university. She did not finish because there came a point in time when she met Craig Ridout, and they decided to marry. They married soon thereafter, and they started a family. Colin, in fact, was the first one born. Based upon Laura's example of her faith and her witness to her faith, Craig Ridout converted to Catholicism. But their marriage was not what the outside world saw. Both of these individuals brought their own problems that affected the relationship. Craig Ridout was diagnosed and treated for a schizoid-type personality, meaning to the outside world, he had an agreeable personality. And according to many of his friends, a delightful personality. But that split in his personality was a different person at home. The Paranello alluded to some of that and some of the trauma that occurred in the house over the entire life of this marriage and these children. He was very distant, unloving toward his wife, almost reclusive. And this impacted his relationship with Laura and most severely with the children. It's interesting, and in fact the Sheriff's Department could probably speak better of this, but in reading over the reports, I noted when they interviewed the children, when they asked about Laura, all the children referred to her as Mom. When they asked about Craig Ridout, they didn't call him Dad, they didn't call him their father, they called him Craig. I think that is just some small way of showing the distance that these children had with their father. Over time, Laura found herself in an abusive relationship, not so much physically, but one that was emotionally and economically abusive. She was alone as a parent. She was raising these children alone, and she was not well. Her entire life, she has suffered and been plagued with migraine headaches. She still has them. She has them all the time. So this was a relationship that was difficult. They did have 7 children, and she bore 7 children with Craig Ridout. But this is in no way proof of a loving marital relationship. 2 of her children were the product of a non-consensual forced sex.
So I object to any matters not in the record for the court.
Well, everybody else is. I'll get right through this.
Overruled.
Marital rape does occur. In both instances, when Laura Ridout learned that she had conceived, she had the option to abort. But due to her strong belief in the sanctity of life, she chose to give birth to these children and to raise these children. Now, I mention that because I need to juxtapose this with something else. These were 2 unwanted pregnancies. She had a legal option to abort these children, but she couldn't do it. She couldn't do it because of her belief in the sanctity of life. And yet she knew that once these children were born, they would be her responsibility from the day they were born until the day she died. And yet the prosecution wants us to believe that she was willing to take the life of Craig Rideout, who was somebody that she was within days of putting in her rearview mirror. She was moving on to North Carolina. So I think you need to look at that in terms of her belief in the sanctity of life and how that impacts in terms of the death of Craig Rideout. I don't believe that part of her inner person, her inner self, was capable of taking a life because of her belief in the sanctity of life. For many years, Laura tried to save this marriage through counseling, but primarily by sheer forbearance. She was suffering so much in the marriage that her parents, her siblings, and even her medical providers urged her to separate from Craig Rideout. But she continued to endure the pain until finally in the fall of 2014, she just couldn't take it anymore, and she moved out. This was an act of pure desperation to survive. Jennifer Tucci and Paul Tucci were the Rideouts' closest friends, and prior to Jennifer's death, she and Paul offered a safe haven to Laura. But Laura didn't accept it initially, and then Jennifer became ill. And subsequent to Jennifer's death, Paul Tucci, a friend, reaffirmed that offer, and she took him up on it. Now, that is a relationship that started as nothing more than a friendship, but it did eventually evolve into a loving, intimate relationship. Now, she started a divorce action in late 2014, as the court is aware, and it continued for the ensuing year to year and a half, rather, up until the time of Craig Rideout's death. And it was nearly complete at the time of his death. But, and this, Your Honor, you have sat, and I know you have sat on divorce actions, so you're aware of the fact that these can become somewhat long and protracted matters, but this was not an unusually long and protracted matrimonial. I mean, there were 7 children, and many of whom had to have a law guardian appointed. There had to be evaluations. There had to be time to create plans for visitation and custody and to see how that was working. And that's exactly what Judge Dollinger was doing over this period of time. In December of 2015, Laura told Craig Rideout that she wanted to move to North Carolina and that she wanted to bring all the children with her. But he rejected that idea. Now, that has been the source of the prosecution's theory that Laura Ridout had a motive to kill on January 20th, 2016. Colin Ridout's attorney reiterated that as well. She had the motive. Really? You remember the testimony of Mr. Fazink. Mr. Pilato cross-examined him. It became very clear that Judge Dowlinger, in February of 2016, had finally issued a third amended custody order. And in that order, he decreed that Laura Ridout would have custody of all the children, but for the two youngest, Patrick and Madeline. And those two youngest would be awarded custody to the father, Craig Ridout. I'm certain in a perfect world, Laura would have preferred to have all the children. But she learned to accept that. And the proof of that is that over the ensuing 4 months, from March of 2016 to June of 2016, she submitted no less than 4 proposed separation agreements. All those separation agreements dealt with primarily were financial matters. And on each occasion when she submitted those to Craig Ridout, he would make corrections, modifications, in order to reduce his financial responsibility. Whatever the reason was, maybe he was having some financial difficulties at the time. I'm not getting into that. But the reality is that she acquiesced to every single one of those demands. With each ensuing separation agreement, it included his latest request for reduction of payment. By state law, by statutory law, he was required to pay $3,300 a month in child support. And by the last separation agreement that was submitted, it was whittled down to $750. She agreed to that amount based upon his request. There was no financial remuneration in this for her whatsoever. She was receiving nothing by way of a life insurance policy or anything else. She wanted nothing from him. But what's important here beyond the financial part, and more important as it goes to the motive issue that both Colin Ridout's attorney and Mr. Prosperi made reference to, is that in each of those separation agreements were attached the third amended custody order by Judge Dowlinger, which was her way of affirming her agreement to accept that order. Now, maybe you find that a bit of an inference, but let me follow up with something, because that inference came to fruition later on. Prosecution presented a lease agreement from June of 2016 when Laura Ridout and Paul Tucci went to North Carolina, Cary, North Carolina, for the purposes of leasing property down there for the impending move in July. And when they did that, the leasing agent had her write down the names of the children who would be residing there. And she wrote down the names of Alexander, Elizabeth, and Julia, the 3 children that were awarded custody to her by Judge Dowlinger. Omitted on that lease agreement were the names of Patrick and Madeline. I submit that that's further proof she had accepted the court's order. There was no motive for her to kill this man. And in fact, I go back to this inner self, this person who believes so deeply in the sanctity of life. What purpose would there be gained in killing this man? None. She had accepted the terms. She was about to start a new life. She was moving away from him. That was the relief in her life. I submit that there's no credible evidence that she had a motive to kill Craig Ridout, and there was insufficient proof that she was either a principal or an accessory. It is incredible to believe that she was the principal, that she was the one that caused his death, that physically caused his death. This is a petite woman of approximately 112 pounds, according to the proof in this case. Did anyone reasonably or seriously believe that a woman of this size could physically overcome her physically fit 191-pound husband and restrain him while he struggled to extricate himself from this garrote? That was the testimony of the medical examiner, as you recall. And what proof is there that she was an accessory? Purchase of items. She went into a store on July 18th with one of her daughters and her son, Colin. Colin made this purchase of liquid lightning. He went out, he made the purchase himself, he went out, he put him in the car himself, and then minutes later, Laura came out with her daughter. They weren't seen in the store purchasing this together whatsoever. He's the only one that made the purchase of those items that day. But even if she knew that those items were being purchased, there's no proof that those items were being purchased for the purpose of the homicide of Craig Ridout or the cover-up of that homicide. To the contrary, the court heard proof, and I'll say I think the jury probably accepted this aspect of the case, that these items were being purchased for the purpose of readying the house for sale in Fairport and for their impending move to North Carolina. Mr. Prosperi made reference to the next day, July 19th, at the Walmart on Hudson Avenue, where she and Paul Tucci entered at 9:30 that evening, literally just hours before the death of Craig Ridout. And at that time, they purchased several items that were used to apparently transport the body and discard the body. But the jury in this case didn't find Mr. Tucci guilty. Didn't find him guilty of that. They disregarded that evidence. They accepted the fact that on that occasion, these items were being purchased, again, for the furtherance of the move to North Carolina and readying the house for sale. Otherwise, they would have had to convict him as an accessory, based upon this court's charge to them, and I suspect they followed that charge closely. They would have had to convict him. They did not. So they didn't convict him of it. There's no basis to believe that there was any way in which that evidence held any further weight against Laura Ridout. She was purchasing it with him. In fact, he made the purchase. Now, I submit it came down to the microscopic particles of Craig Ridout's blood in Massimo jeans. But even the district attorney's blood analyst reluctantly had to acknowledge that he couldn't differentiate between the spatter on the jeans and whether or not that came from an impact spatter or whether or not it could have been caused by another mechanism, such as cleaning in the basement by using a brush or some type of utility item like that. He indicated, and it's clear in his testimony, that the spatter on those pants could have been caused by either fashion. These are two different mechanisms. One of them, he testified that in his opinion, she would have had to have been in close proximity to this impact moment. But then he also said that he couldn't differentiate between the spatter on the pants and on the jeans and whether or not they could have been caused by a brushing motion, because that can cause the same type of spatter on fabric. No, rather, the blood proof in this case established the true identity of the murderer, as the shroud of Craig Ridout was imprinted on the clothing of one person, Colin Ridout. Not Laura's clothes, Colin's clothes. And the only proof that she was ever inside 135 New Wickham Drive was at 1 p.m. on July 20th, some 10 hours after Craig Ridout's purported death, when she was admittedly cleaning up a bloody scene in the basement as established by the proof of the trial and as confirmed in her statement to this court. Therefore, contrary to the jury verdict, I do not believe Laura Ridout was either the principal or accessory to the murder of Craig Ridout. Now, this is a woman who, in this courtroom, has been much vilified. I know she's also been vilified in this social media. I don't do it. I don't even know what Twitter is. I read about it. I hear about it. I don't know how to do it. I got all these young lawyers, and they read this stuff. And some of it has been printed out, and I've read it. Vicious attacks on this woman. Vicious attacks by people that don't know her, don't know anything about her, don't know anything about what I've said today about her life and the failed marriage that she was in. Many of the letters that came from the prosecution, again, vilified her and saying what kind of mother wouldn't stand up for. Mr. Parinello said the same thing today in his closing. What kind of mother wouldn't stand up, throw herself on a sword for her children? But she actually attempted to do that. The court's aware, Mr. Prosperi and Mr. Egan are aware. We attempted to work out a plea deal where she would plead to a homicide charge, even though she couldn't colloquy to it because she didn't commit it. But she was willing to do it for the sake of her children. That offer that we made to the prosecution was rejected. But she's vilified. The two final points. Purpose for any trial is the quest for truth, culminating in a jury verdict. The word verdict, in fact, is derived from the Latin meaning speak the truth. In most cases, I think we're able to do that. In some cases, however, as in this case, I submit the whole truth did not bear witness. For many reasons, some of which I bear responsibility for strategies that I pursued as a result of a joint trial, and some of which our rules of evidence would not allow. This jury never learned all the facts. Hopefully, as a result of this proceeding today, some of the blanks have been filled in, not just for the jury, but for the public and for this court. And then finally, I stand here today as a lawyer on the sentencing of our client, Laura Ridout. And I can only plead for mercy for her. Judge, as the civil authority, you have the power to right a wrong. You have the power to temper this sentence with mercy, and I beseech you to do that by imposing a minimum sentence. Despite our efforts, our temporal efforts here on earth, Laura Ridout's judgment will ultimately be decided by God Almighty. And my prayer today is that any judgment of Laura Ridout, any judgment that I've made of Laura Ridout today as being innocent of the crime of homicide is confirmed by God himself. And that judgment of vindication for her will last for eternity. Thank you, Judge.
I'm going to take about 5 minutes. I want to read Alexander's letter, and I will be back.
Maybe approach the counsel.
Oh,
All rise.